Hi, I'm Phil McNulty. I'm a district court judge for the 1st Judicial District, and that includes both Jefferson and Gilpin counties. Judges who handle criminal cases regularly see mental health issues arise with defendants. Although judges have neither the expertise nor the information necessary to render a psychological diagnosis, judges must be aware of the behavior of defendants in the courtroom and must be sensitive to when the law triggers certain obligations. An unruly defendant may simply be angry about being charged, or his behavior might be symptomatic of something more serious. An unresponsive defendant might simply feel intimidated by being in front of a judge, or she may have no rational understanding of what is occurring in the course of the proceedings. This presentation will focus on the fundamentals of two important mental health topics in criminal law: competency and sanity. Competency focuses on the mental state of the defendant throughout the legal proceedings, while insanity focuses on the mental state of the defendant at the time of the alleged crime. Competency does not imply sanity, and sanity does not imply competency. The two concepts are categorically distinct. It is a violation of the constitutional right to due process to try an incompetent defendant. A finding of incompetency suspends the criminal proceedings, and the defendant may be committed to the Department of Human Services until the defendant has been restored to competency, at which time the proceedings are resumed. If the defendant cannot be restored to competency, he or she may only remain committed for a period equal to the maximum period of confinement that could be imposed for the offenses with which the defendant is charged. Insanity is an affirmative defense to the charged crime. A defendant found not guilty by reason of insanity is acquitted of the crime, but is deemed by law to be dangerous and is therefore committed to the Department of Human Services until such time as the defendant is found eligible for release. The commitment is indeterminate in length and may be for the remainder of the defendant's natural life. Competency and sanity are legal concepts. Mental health diagnoses, such as schizophrenia or bipolar disorder, are psychological concepts. Understanding the probative value of a mental health diagnosis to the legal determination of competency and sanity frequently requires an expert opinion from a forensic psychologist or psychiatrist. A forensic mental health expert is trained in the legal standards for competency and sanity and is practiced at determining whether a particular defendant's mental condition meets the standard. Of course, such experts frequently disagree, and the court may be called upon to decide which expert is correct. However, it is important to understand that although a mental health diagnosis is a necessary condition for a finding of either incompetency or insanity, such diagnosis alone is not a sufficient condition for a finding of either. Simply having been diagnosed with schizophrenia does not mean that one is incompetent or insane. State Statute 16-8.5-101, subsection 11, provides as follows. Incompetent to proceed means that as a result of a mental disability or developmental disability, the defendant does not have sufficient present ability to consult with the defendant's lawyer with a reasonable degree of rational understanding in order to assist in the defense, or that as a result of a mental disability or developmental disability, the defendant does not have a rational and factual understanding of the criminal proceedings. The issue of the defendant's competency is most frequently raised by defense counsel because defense counsel has had the opportunity to speak with the defendant in private and assess the defendant's ability to assist in his or her defense and to understand the nature of the criminal proceedings. However, statutes provide that competency may also be raised by the prosecution or by the court. Of course, the court's information about whether the defendant suffers from a mental or developmental disability typically comes from the probable cause affidavit and observations of the defendant in the courtroom. This information is usually quite limited, since there are serious consequences for the defendant when competency is raised, as will be discussed in a moment, it is prudent and common for the prosecution and the court to defer to defense counsel on this issue. However, deference is not abdication, and sometimes the defendant has elected to represent himself and may not be aware of his own incompetence. So what standard must be met to warrant the raising of competency? The standard for raising competency is quite low. Case law provides that if the court or counsel has a reasonable doubt about the defendant's competency, then they are duty-bound to raise the issue. Statutes require counsel to raise the issue of competency in writing prior to the commencement of particular judicial proceedings. However, the motion may be filed after the commencement of the proceedings if, for good cause shown, the disability of the defendant was not known or apparent before the commencement of the proceeding. Such motions are to be sealed by the court. State Statute 16-8.5-103 provides in part, whenever the question of a defendant's competency to proceed is raised by either party or on the court's own motion, the court may make a preliminary finding of competency or incompetency, which shall be a final determination unless a party to the case objects within 14 days after the court's preliminary finding. If either party objects to the court's preliminary finding, or if the court determines that it has insufficient information to make a preliminary finding, the court shall order that the defendant be evaluated for competency by the department and that the department prepare a court-ordered report. It's not common for the court to find a defendant incompetent based merely on courtroom observations. Most of the time, the court has insufficient information to make a preliminary finding, and the court orders that the Department of Human Services evaluate the defendant for competency. A competency evaluation consists of one or more psychologists or psychiatrists reviewing the defendant's mental health records, observing and interviewing the defendant, and conducting psychological testing of the defendant. This procedure necessarily raises questions about doctor-patient privilege, the defendant's right to remain silent, and his or her obligation to cooperate with the evaluation. The defendant must also be advised of his or her right to contest any conclusion reached by the evaluators. The advisement of rights usually includes notice to the defendant of the following. The defendant will be evaluated by one or more physicians or psychologists. If the issue of competency is raised by the defense, then it constitutes a waiver of privilege to previous or subsequent competency evaluations. The defendant has the right to remain silent during the evaluation. However, such silence may be used by the evaluators to determine defendant's competency. Any statements the defendant chooses to provide in cooperation with the evaluation may be used by the prosecution as either impeachment or rebuttal evidence if the defendant testifies at any subsequent criminal trial. Any statement the defendant chooses to provide in cooperation with the evaluation may be used at any sentencing hearing held in the criminal trial if the defendant is found guilty. The defendant has a right to request an evidentiary hearing to contest any determination of competency. The defendant has the right to be examined by an expert of defendant's choice on the issue of competency. A copy of any report generated by that expert will be provided to the prosecution. At such hearing, the defendant has the right to be present in person, to examine any reports of the evaluation or other matters to be considered by the witnesses called by the court, to introduce evidence, summons witnesses, cross-examine opposing witnesses or witnesses called by the court, and to make an opening statement and closing argument. If the defendant is found incompetent to proceed, then the criminal proceedings would be suspended and the defendant will be committed to the Department of Human Services for a period not to exceed the maximum term of confinement that could be imposed for the offenses with which defendant is charged. If found incompetent to proceed and subsequently committed, the defendant has the right to request a hearing as to whether his or her competency has been restored. If competency is restored, then the criminal proceedings will resume. Competency evaluations can occur both in custody and out. The location for the competency evaluation has recently been the subject of legislative changes. Consult the latest statute to determine what options exist for the court. It typically takes the Department of Human Services between 60 and 90 days to complete the competency evaluation. Once completed, the department will forward a sealed copy of the written report to the court and counsel. Within 14 days of the court-ordered report, either party may request a hearing or a second evaluation. If neither party requests a hearing or second evaluation, the court shall enter a final determination based on the information then available. The competency hearing is a special statutory proceeding, the rules of which are dictated by Article 8.5 of Title 16 of the Colorado Revised Statutes. In preparation for the hearing, the court will order the defense and prosecution to exchange the names, addresses, reports, and statements of any physician or psychologist who has examined or treated the defendant. At the competency hearing, the party asserting the incompetency of the defendant has the burden of proof by a preponderance of the evidence. Upon a finding of incompetency, the court may commit the defendant to DHS for restoration treatment or make restoration treatment a condition of bond in either an inpatient or outpatient setting through another provider. There is a presumption that incompetency inhibits the ability of the defendant to ensure his presence at trial. If the issue of the defendant's competency is raised after a defendant has entered a not guilty plea, the speedy trial time period is told while the defendant is incompetent or under observation for a determination of competency. Now let's turn our attention to the affirmative defense of insanity. The defense of insanity may only be raised by a specific plea at the time of arraignment. A plea of not guilty by reason of insanity, also referred to as NGRI, automatically includes a regular not guilty plea. An NGRI plea may only be raised after arraignment if good cause is shown. Before accepting an NGRI plea, the court must advise the defendant of the effect and consequences of the plea. The advisement of rights usually includes notice to the defendant of the following. Every person charged with a crime is presumed sane. However, once any evidence of insanity is introduced into evidence at a trial of those charges, then the prosecution has the burden of proving the defendant's sanity beyond a reasonable doubt. By pleading NGRI, the defendant has placed his or her mental condition at issue, and the court will order the defendant to be evaluated by one or more psychiatrists or psychologists. The mental evaluation will occur at a location chosen by the court, either at a Department of Human Services facility, the jail where the defendant is incarcerated, or at some other location with priority being given to the location where the defendant is incarcerated. To aid in forming an opinion as to the defendant's mental condition, it is permissible for the examining psychiatrist or psychologist to use any admissions or confessions made by the defendant and any other evidence of the circumstances surrounding the commission of the alleged offense, including the defendant's medical and social history. In addition, it shall also be permissible to conduct a narcoanalytic interview of the defendant with such drugs as are medically appropriate and to subject the defendant to a polygraph examination. The examining psychiatrist or psychologist may testify to the results of such procedures at the criminal trial. The defendant has the right to be examined by a psychiatrist, psychologist, or other expert of his or her choosing. A copy of any report of examination by the defense expert will be furnished to the prosecution. By pleading NGRI, the defendant is waiving any claim of confidentiality or privilege in defendant's existing mental health records, and the court will order the defense and the prosecution to exchange the names, addresses, reports, and statements of any physician or psychologist who has examined or treated the defendant for such mental condition. The defendant has the right to remain silent during the court-ordered mental examination. However, such silence may be used by the examining psychiatrist or psychologist in determining the defendant's sanity. The defendant is required to cooperate with the mental examination. If the defendant fails to cooperate, then the court may preclude the defense from calling a psychiatrist or psychologist or other mental health expert to testify at the trial. Further, the fact of defendant's non-cooperation may be admissible at trial to rebut any evidence introduced by the defense regarding the defendant's mental condition or at the sentencing hearing if the defendant's convicted at trial. If the defendant testifies at the criminal trial, then any statements made by the defendant to the examining psychiatrist or psychologist may be used as rebuttal or impeachment evidence or at a sentencing hearing if the defendant's convicted at trial. If the defendant is found insane, then the defendant will be committed to the Department of Human Services for treatment for an indefinite period of time until it's determined that the defendant is eligible for release pursuant to law. If so committed, the defendant is entitled to a hearing as to whether the defendant's sanity has been restored, and if so restored, then the defendant will be released pursuant to law. If found guilty at trial, then the defendant will be sentenced according to state law and the jury's verdict. Colorado law provides for two forms of insanity. The first form of insanity focuses on a person who is incapable of distinguishing right from wrong. The second form of insanity focuses on a person whose mental illness prevented him or her from forming the culpable mental state. CRS 168-101.5 provides in part, the applicable test of insanity shall be a person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable. Or a person who suffered from a condition of mind caused by a mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of a crime charged. Both statutory definitions of insanity come with the following caveat. But care should be taken not to confuse such mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when the act is induced by any of these causes, that person is accountable to the law. Further definitions also limit which mental conditions qualify for insanity. Diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Mental disease or defect includes only those severely abnormal mental conditions that grossly and demonstratively impair a person's perception or understanding of reality, and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance, but does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. If the fact finder returns an NGRI verdict under either form of insanity, then the result is the same. The defendant is committed to DHS for an indefinite period until eligible for release pursuant to law. Judges should note that prior to July 1995, the second form of insanity was codified under its own statute and referred to as the defense of impaired mental condition. Today, we no longer refer to the separate defense of impaired mental condition. Today, we simply refer to both as the defense of insanity. In addition, both forms of insanity need to be distinguished from another related defense, namely a mental condition defense. This refers to those situations where the defendant enters a regular not guilty plea, but endorses a mental health expert to testify at trial about some aspect of the defendant's mental state. Such a situation involves procedures which are a hybrid of a regular not guilty plea and an NGRI plea. Mental condition evidence does not always relate to insanity. Sometimes mental condition evidence relates to a simple negation of mens rea. All criminal defendants have the due process right to defend themselves by contesting the existence of the culpable mental state. They may even use expert testimony in the process of doing so. However, the court is obligated to make sure that the defendant does not attempt to argue insanity without entering NGRI and subjecting him or herself to the procedures of the insanity scheme. Mental condition evidence, which is used as a simple negation of mens rea, is distinguished from insanity by the concept of capacity, namely, whether the defendant is arguing that he could not form the culpable mental state versus arguing that he did not form the culpable mental state. If a defendant is claiming a lack of capacity to form the culpable mental state at the time of the crime, then the defendant must plead NGRI. In contrast, however, if the defendant is conceding that he or she had the capacity to form the culpable mental state at the time of the alleged crime, but is simply arguing that he or she did not form the culpable mental state, then such a defense may be raised by a regular not guilty plea. Sometimes mental condition evidence is not a simple negation of mens rea, but involves the use of expert mental health testimony for some other purpose, such as disclaiming the voluntariness of a confession, or using expert mental health testimony for some purpose other than claiming an incapacity to form the culpable mental state. However, it's important to note that regardless of the purpose, if the defendant wishes to endorse an expert to testify regarding mental condition evidence, then the defendant must endorse such expert at the time of arraignment and subject him or herself to a court-ordered mental evaluation. If acquitted, the defendant is no longer under the jurisdiction of the court, as is the case with any regular not guilty plea. Because insanity is an affirmative defense, the prosecution has the burden of disproving insanity, as well as proving the elements of the charged offense beyond a reasonable doubt. For this reason, the prosecution may present evidence of sanity in the prosecution's case in chief. This means the statements made by the defendant to the psychiatrist during the court-ordered mental evaluation may be coming into evidence in the prosecution's case in chief, in spite of the fact that the defendant had a Fifth Amendment right to remain silent at the time the statements were made. It's important for a trial judge to understand that evidence of sanity introduced in the prosecution's case in chief is being admitted for a limited purpose, namely, for the purpose of determining the defendant's sanity, and not for whether the defendant is guilty of the charged offense, and the jury should be so instructed. Otherwise, such use would violate the defendant's right to silence. The importance of the limiting instruction cannot be overstated. It should be given immediately preceding any testimony regarding the defendant's mental condition. It's also worth mentioning that testimony regarding a defendant's sanity or mental condition is not limited only to experts. Lay witnesses may also testify regarding the defendant's mental condition in the form of opinions or conclusions, as long as the lay witness was sufficiently familiar with the defendant near the time in question. Competency and sanity are complex areas of criminal law, controlled by statutes and evolving case law. Any trial judge handling these issues, as always, needs to be aware of the latest appellate opinions.